the court had this massive social, moral capital in this country. The American public is like, okay, we're not going to take to the streets when the court hands down a decision because the court is different, because the court is above politics. And then you have a court that's just utterly willing in the span of a couple of years to squander that capital and to say, we don't care what the public thinks. We're going to do what we want.
This is Brad Rourke with the Charles F. Kettering Foundation. We're a nonprofit, nonpartisan operating foundation that focuses on advancing and defending inclusive democracy. Today, I'm talking to Dahlia Lithwick, award-winning senior editor at Slate, regular contributor on MSNBC, and host of Amicus, the award-winning podcast about the Supreme Court that we all must listen to. Her latest book, Lady Justice, is a New York Times bestseller. Dahlia knows what she is talking about when it comes to the Supreme Court. We're coming up on what's surely going to be, I guess I could say, an energetic June when it comes to the Supreme Court. Numerous opinions on high-profile cases coming down the pike. But meanwhile, there is now a multi-week controversy having to do with Justice Samuel Alito and various versions of the American flag. You recently wrote a piece unpacking this and devoted a podcast episode to it just a few days ago. What are the facts we need to know?
I mean, I think at the most granular level, the facts are that the New York Times, Jodi Kantor and her team did a deep dive and found out that in January of 2021, just around the time of the January 6th rally at the Capitol that turned into a riot, a violent riot, not in the days after that, while the sort of Stop the Steal movement was kind of peaking, that the Alitos had flown in their home in Virginia an upside-down American flag, which is sort of universally understood to be a signal of distress. Initially, ships at sea would fly an upside-down flag to suggest that they were in distress. It had come to be a kind of Stop the Steal, the country's going down the tubes flag, and it was very much in evidence on January 6th at the violent riots. And then there was a sort of a very strange back and forth with Justice Alito in the Times, where he suggested that this was done because his wife was in a fight with the neighbors. It had nothing to do with Stop the Steal. Martha Ann Alito was just upset because the neighbors had used expletives at her around the election results. And the third thing that's sort of essential here is this is at a moment when the Supreme Court was actually considering taking cases that had to do with claims that the election had been stolen. So that's one chunk of it. And then the follow-on chunk, which came a week later, again, Jodi Kantor and her team at the New York Times, reporting that just last summer, the Alitos were flying a different flag associated also with Stop the Steal, but also associated with a kind of slightly radical kind of Christian, very, very violence curious and insurrection curious flag that, again, I think raised real questions about what she was signaling, why it was being flown, and this was happening just this past summer. And then there's a sort of a merits question underneath it, which is, what does all this signal about Justice Alito's sort of appearance of impropriety is the ethical standard in terms of deciding January 6 cases?
It might be worth unpacking this sort of emphasis and obsession with the revolution and independence. Is there a growing movement among certain people who see themselves as part of a second revolution, and why does it matter if there is?
I don't think there's any doubt that so many of the MAGA roots, particularly of the January 6th insurrectionists, were rooted in the notion that it's time for another revolution, that, the whole effort to set aside the election with, all of the iconography and all of what has arisen since, when you talk about, Ashley Babbitt, when you talk about the music that has emanated from that. I think it's all of a piece, and it is all a way of saying the only way to overthrow this lawless Biden administration is through acts of self-help and violence. And you're exactly right. I think it harkens to the mythology of the revolution, the original revolution and the founding, and the notion that when you are subject to an immoral crown, the only thing to do is violent insurrection. And so you're right that each of these flags and signifiers catches a different piece of that reverence for the notion that, and as I say, I think that it is very, very, this part of the story I think hasn't gotten quite enough attention. But I think that there's also a deeply religious valence to this, right? That at the end of the day, if man's law is unjust or immoral, then you seek God's help to do something different. And that's also a revolutionary idea. And it's braided in very, very tightly with some of the political revolutionary ideas, these theological revolutionary ideas. And I think one of the things we sort of failed to take seriously around January 6th, and it's important to listen to people like Jeff Sharlet about this and other scholars who think about it, that this notion that this is actually what God wants us to do is a huge driver of some of these revolutionary concepts.
Perhaps no surprise. According to Gallup, trust in the Supreme Court is at a record low. Less than half of Americans trust the Supreme Court. One question is, should the court care? You've said yes. Why?
I think that the court is a unique entity in that, and this goes right back to the Federalist Papers, and this goes right back to the theory at the founding, which is it is supposed to be the least powerful branch, right? It has neither the purse nor the sword. If you look at the Federalist Papers, all it has is public estimation and public confidence. It has no army, right? It can't, if Congress decided to just shut the lights, Congress could shut the lights. And so this power that it has, which is hard fought, right? When John Marshall announces, that, we get to be the deciders in Marbury v. Madison, that's an astonishing proposition. And it takes a long time for the American public to get to the place where they say, here's this third co-equal branch of government that has no power. And yet when they hand down a ruling, we're just going to accede to it, right? That's Bush v. Gore. And so I think that tenuous grip on power, which is so profoundly connected to public confidence, is something that has been so utterly squandered, not just, in rulings. I think that's a piece of it, right? You can talk about Bush v. Gore, you can talk about Shelby County versus Holder, you can talk about whatever case, name it, and where it seems as though the court has been overturning precedent without caring, has been rewriting huge doctrines, the major question doctrine. What is that? Nobody knows. What is the independent state legislature theory? Nobody knows, right? The court is making it up on the fly. So there's the doctrinal lack of confidence that really, I think, achieves this zenith in Dobbs. And with the Dobbs leak, by the way. And then there's this other story, which is judicial conduct. And that gets reported as, and another Koch brothers conference and another trip, another flying off to Europe to give a speech that is funded by somebody with business before the court. Those are not separate stories. Those are deeply intrinsically connected stories about what Senator Sheldon Whitehouse has, I think, not wrongly dubbed a captured court, a court that has special interests that are not always disclosed. That has business before the court, and then they seem to be kind of currying favor and influence with certain justices, and none of this is visible to the American public. And that's why, as I said, I think having investigative reporters start to do that work became essential. And so I think the answer to your question is that the court had this massive, massive social, moral capital in this country that was hard fought after Brown v. Board, that was hard fought after Roe v. Wade. Time after time, I think the American public, right, was putting up impeach Earl Warren stickers. And you get to the point finally, and Justice Breyer always writes about this in his books, that the American public is like, okay, we're not going to take to the streets when the court hands down a decision, because the court is different, because the court is above politics. And then you have a court that's just utterly willing in the span of a couple of years to squander that capital and to say, we don't care what the public thinks. We're going to do what we want.
Is there a way to draw a line between all of that and democracy?
I think so. And I think, some of the work that's being done by folks like Mike Podharzer right now, and people should subscribe to his new newsletter. He's trying very, very hard to connect the abstraction that is democracy to the abstraction that is the court. And I think some of the themes that he's pulling on that I've been thinking about for a long time are, what does it mean when you have a president who is elected by a minority of the country, picking Supreme Court justices that are then, right, confirmed by senators that reflect a minority of the country, right? South Dakota has the same number of senators as California. And then you have justices who are confirmed under that, right, minority majority president, minority majority Senate. And then you have a minority rules Supreme Court, right? So the bulk of the justices are not in any way subject to majoritarian checks. And then you have the institution itself that, by design, to be clear, is not subject to majority checks, right? That's why you have lifetime appointment. That's why you can't be removed except for high crimes and misdemeanors. But when you have entrenched layers and layers and layers and layers of minority control, so we have to be for a minoritarian court doing justice, and nobody is against that. The question is, what do you do when that court has been so captured, again, to use Senator Whitehouse's rhetoric, by a handful of groups that appear in case after case after case, who really are pouring money into the Supreme Court Historical Society, pouring money into relationships with justices. We're just seeing reporting this week about money being poured into academic positions to file amicus briefs, and this entire complicated machinery of taking ownership of, we're going to get these people confirmed, we're going to get them to sit on the courts, we're going to bring the cases, right? It doesn't look like a laboratory anymore in which these independent scientists are doing chemistry experiments. It looks like the entire lab and the scientists were bought and paid for by special interests. And I think the democracy subversion isn't the fact that one of three branches of government sometimes is a check on majority rule. That's important. That's by design. The problem is how easy it was to purchase that branch of government.
Is there a corrective to this capture?
I mean, I think that there are a whole host of correctives, and some of them are court reform correctives, right? Some of them are a recognition of the fact that no other constitutional democracy in the world has a court that is as monarchic as the U.S. Supreme Court is now, right? So that means term limits, right? It means some standard for removal that isn't as high as high crimes and misdemeanors. It is, right, there are 13 circuits. There should be 13 seats. So it's adding seats to the court. So there's a whole bunch of systemic court reforms up to and including jurisdiction stripping, right? Maybe the court shouldn't get to decide that the Voting Rights Act falls in its entirety, right? There are ways around this. And I think in addition to sort of the court correctives and the sort of slightly circumscribing the power of 9 unelected people to do what they want, I think there's also a sort of democracy lifting set of correctives that have to do with voting rights and gerrymandering. And in other words, I think both have to happen. We have to really think very, very hard about all of the questions that we currently feel paralyzed by, whether it's, independent districting, figuring out why it is that we're allowing representatives to choose their own electorate. There are so many easy fixes, mail-in voting, right? Take off a day for election day that other democracies do in order to encourage democracy to flourish rather than to discourage it. And so I think it has to be I guess I want to say a leveling of both decreasing the court's power to suppress democracy through, whatever it is, voting rights, campaign finance reform, whatever it is, and at the same time bumping up every mechanism we can possibly have. And so I think this is a failure of imagination more so than of systems. And I think we have to imagine our way to being powerful and imagine our way out from under the thumb of a court that feels as though we just have to succumb to sort of a monarchic view of unchecked power.
Dahlia Lithwick, host of the amazing Amicus podcast, thank you for being with us today.
Thank you, Brad.